if you're not following the same legal processes in an arbitration, if we've accepted that some of those terms are not the same, can you use those terms to overturn a judgment?
The standards are completely different. The standards for appellate review in a legal proceeding are totally different than the standards for arbitration review. In fact, you'll find, I agree, I'd say less than 1% of the time can you get an arbitration award overturned. One of the reasons, I'm not speaking for the AAA now, I'm speaking with regard to NEST and New York Stock Exchange, is you don't get reasoned awards. That is,
oh, I see.
You get $100,000. You get $10,000. Your case is dismissed, and that's it. You don't know.
You don't get a judgment.
You don't get
like
a decision of findings of fact and conclusions of law, which would let you have a basis upon which to go ahead and attack that award. So it gives you a very difficult role, a very difficult hurdle to overcome. Many people say manifest disregard of the law is one of the criteria for setting aside an award. I think if you look at the history of at least securities cases, most awards that have been set aside are usually an arbitrator not allowing in a vital material piece of evidence, excluding that
would have been
objection.
Important.
That would have been important for the arbitration panel, or even more important, undisclosed bias. There was a famous case against a brokerage company in which they awarded hundreds of thousands of dollars and then later found out that the arbitrator's daughter had been terminated from the brokerage company, and he had an obvious bias against the brokerage company.
All right, so, well, you do have to be vigilant if you're in an arbitration.